Hello, Elliot and Wendy. You were the first two to arrive. Welcome, welcome, welcome.
Hi, Gordon.
Hi, everyone. It is now 3 o'clock Eastern Time. Good afternoon. Thank you for participating. I am going to give it another minute or two before I start the formal presentation, because I know that a number of folks that signed up haven't logged on yet, and I want to give them a few minutes for technology difficulties, etc. Also, if you could please leave yourself on mute. I am going to record this session, and there are folks that are going to watch the recorded version. I want to give them the best quality they can get, and that way there's no background noise or sound that will interfere with that. So I appreciate that. I just want to do a quick sound check before I get started. If somebody would let me know whether the sound quality is coming through clear enough, and then I'll proceed.
Sounds great to me.
Thank you. All right, well, let's get started. Again, thanks for joining me. I thought it was opportune for us to talk about vaccines in the workplace, given the now two manufacturers have gotten green lighted for dispensing of the vaccines. And so the issue now is, what can you do in the workplace? Most of you on this call know that this firm is Fisher Broyles, and I'm just going to go quickly through. Many of you know me as in fact, everybody who signed up is in the PEO space. So many of you know me in the PEO space. However, I just want to remind you the firm is full full service nationwide, and we do a lot of things that you may or may not realize. So if you need help in other areas, I just wanted you to be aware that we have this capacity around the country, as well as in London at this time. So the fundamental question we're going to go over today is, should you require vaccinations in the workplace? And for the majority of you, the question is, should you advise your clients, since you're mostly PEOs on this call, whether or not they should require vaccinations? To give you a little context, so there's a few polls that have been taken, one from last week through Yale, and the participants were CEOs of major companies. 72% said they would be open to vaccine mandates, but a lot of them have sort of a wait and see approach, including whether or not if there becomes a mandatory federal or state vaccine requirement. I also read today in a poll that 49% of employees polled favor mandatory vaccinations. So interesting, we'll see what happens. Obviously, it's just rolling out now, and most people aren't eligible to receive it as of yet. So given the landscape, what should you do? Well, you are free to mandate that employees be vaccinated, but you have to be cognizant of employee rights, which includes whether a disability or a bona fide religious belief would validate the employee's desire not to be vaccinated. That, as we're going to discuss, will be weighed with whether or not the employee has any ability to be accommodated, or whether the issues result in a possible risk to others. So again, I'll go over that. So the predominant issue in the workplace, it seems, is related to EEOC and discrimination as far as COVID testing, and including, the vaccines that we're talking about. And, this issue came up with temperature checks earlier in the pandemic. And there's some similarities, but of course, a vaccine is more invasive than simply using one of those touchless temperature checks. But the analysis is fairly similar. And so you'll note here that the EEOC came out with the following, and I quote it because it's part of a directive that came out by the EEOC, and I've cited what it's called at the bottom if you want to read the whole thing, but I pretty much am going to cover that directive here. So obviously the EEOC is essentially saying, our laws that we enforce continue to apply during the pandemic, but we're going to obviously not interfere or ask you to violate any kind of health directive that you may be subject to, and you should take heed to those directives. And those directives are subject to change, and so you got to stay current to maintain workplace safety. So there's no sort of in cement hard and fast rule here that we're going to apply. All right, so one question is, just like a temperature check, is a vaccine considered a medical exam under the Americans with Disabilities Act? And the short answer is no. And why? It's because it's not a medical exam by definition. Now, understand that we need to make a distinction here between a rule related to whether you as an employee were to go out and get your own vaccine from your own health care provider versus an employer administering a company policy of giving the actual vaccines to employees through contracted or directly. So when I say no, it's not a medical exam, we're assuming you're not going to obtain information about the person's medical history or health status, which makes it not a medical exam. Like I said, in the same way that the temperature checks are not considered medical exams. However, there's another component to this, because along with administering the vaccine is the best practice recommended by the CDC, which I'll go into a little more in a few minutes, but there's going to be a pre-screening questionnaire that each employee would be required to answer. And in which, of course, the answers might direct you to disability-related inquiries, which then give you information about a disability, which could then implicate the Americans with Disabilities Act. So do care if you're going to administer vaccines yourselves as an employer, or advise your clients to do that, that you have to show, and this is the key, it has to be job related and consistent with business necessity. Now, this is the thematic premise of the EEOC's directive that just came out. This seems to be the only example where they are suggesting that it's permitted to mandate vaccines if it's job related and consistent with business necessity. So it can't be for random, arbitrary, non-work related reasons. So I point that out because obviously that's a key here, and we're going to be talking about a lot throughout the course of this presentation. So screening questions. Here's an example of questions that a person may be asked before they are administered the vaccine. And note here at the above, CDC does recommend that healthcare providers should ask certain questions to make sure that, they're not going to be improperly receiving the vaccination, or that it might create health issues or complications by receiving it. Like for example, certain health conditions or drug interactions could result in the person not being a candidate for the vaccine. So here are examples of questions. Now, you can imagine the majority of these questions can arguably result in disability-related information and therefore could imply the ADA. So that's where the challenge is for the employers. And because of this, if you do mandate that as an employer that all employees have to get an employer-administered vaccination, as I said, you have to show it's job-related and consistent with business necessity. Now, the standard is having a reasonable belief based on objective evidence that an employee who doesn't answer the questions, which obviously would then not allow them to get a vaccination, will pose a direct threat to the health and safety of himself or others. So the direct threat, again, is part of a standard here. It also is an OSHA standard that I'm going to allude to later on, but it has to be a direct threat, not, so objectively, okay? So in a vacuum, if everyone at the workplace but one person got the vaccination and the person refuses to complete the questionnaire, is that an objective basis to conclude they pose a direct threat? So, it's questions like that. And so the EEOC goes on to talk about two circumstances where disability-related screening can be asked without it being job-related and consistent with business necessity. So if you offer the vaccination to employees on a voluntary basis, therefore, if it's voluntary and I choose not to get the vaccine, which means I'm not going to answer the pre-screening questions, then that's considered voluntary and permitted. If the employee refuses to answer the questions in a voluntary setting, as you can see here, you don't give the vaccine, but you can't retaliate against the employee for making that decision. Okay. The other, where it doesn't have to be job-related circumstance, is if the employee receives an employer-required vaccination from a third party that does not have a contract with the employer. So like they go to a pharmacy, CVS is one of the pharmacies that's doing a lot of this for nursing homes, et cetera, or other provider. That doesn't apply because the employer isn't in the loop if you think about it. They're not privy to anything that might be discussed or revealed in a questionnaire. So another question, this is just like with COVID testing. Can I ask for proof of receipt of disability related reasons that you didn't get vaccinated? I'm sorry, it's asking for proof disability related. So if I say to you, did you get the vaccine? And you just answer me, no, in a vacuum without any further information, the answer is no. And of course, there's many reasons why somebody may not be vaccinated, and it doesn't have to be disability related. So that in of itself is considered okay. But if you ask follow-up questions like, why didn't you get vaccinated? you'll be going down a path where that employee is going to be revealing disability information, and that might be getting into the ADA. Are you asking questions that are job related and consistent with business necessity? So, that's again where the risk lies. Now, and this is fine, if you choose not to do an employer-sponsored or coordinated vaccination program, if you're going to have your employees go get their tests, their vaccinations of their own, outside of your employer-controlled environment or provider, make sure that you tell them that they shouldn't provide any medical information when they submit their proof of receipt, because you don't want to violate the ADA. And this is something that you may wish to put in some kind of written agreement or notice, and it's something I can help with if you need me to. But I think always documenting, what you tried to do here in compliance with the law will go a long way to mitigate from violating rights. So let's go with the scenario of, what if an employee says you can't get a vaccine? Okay, we go back to the direct threat standard. But if by using a safety qualification such as vaccination is considered a mandatory safety, and that screens out somebody with disability, you have to show that they would pose a direct threat, and it's significant risk of harm to the health and safety of individuals or others, and it cannot be reduced by reasonable accommodation. Okay, so again, this is a case-by-case analysis, and it's going to be entirely different every client worksite, even your own office. And so the EEOC identifies 4 factors of what may constitute a direct threat. So it's the duration of the risk, nature and severity of the harm, likelihood of harm will occur, and the imminence of the harm. Now, those may sound somewhat subjective to a non-expert, but that's the standard. And so they give an example of what a direct threat would be, which would be an unvaccinated individual could expose others to the virus at the work site. I mean, that's pretty straightforward. If somebody does pose a direct threat, you can't just say you can't come to work or you're fired. The EEO says you must first show there's no way to provide a reasonable accommodation, which, as most of you know, under the ADA, an undue hardship does not then mandate you accommodate somebody. So if it's, cost prohibitive or it's just completely impractical, that's not considered a reasonable accommodation. So if you can eliminate the direct threat by accommodation, then obviously you have to take those steps. And again, I'm going to talk about what examples of what that might look like. Obviously, if you figure out that you have a direct threat, you can't reduce it to an acceptable level, such as you don't have the ability to do some of the things that are right now required, like social distancing. The person's going to come in close contact for 15 plus minutes with some coworkers, et cetera, things that could obviously create a COVID risk. You could possibly exclude the employee from coming to your physical location. But obviously, again, you may have other obligations, such as accommodating by allowing remote work. You might have to look at relocating the worker to a different part of the facility where they're more isolated. I mean, there are a number of steps you can take. It's the same thing with trying to keep workers from exposure when we were talking about general COVID best practices. Again, the FFCRA will come into play, and some of you may note that the new law, the stimulus bill that was passed, does extend FFCRA to some degree. That's a webinar for another day, but or it may be general FMLA rights. So you have to look, again, the facts and circumstances. Not every job can be done remotely, and not every accommodation is reasonable. So it's going to be case by case, fact specific. What I found with a lot of PEOs during the pandemic was folks that were doing the actual payroll or having to cut checks were essential and had to be in the office. And so the accommodation of working at home, they couldn't print checks. That may be a real world example where you couldn't accommodate that person in this scenario. All right. And of course, and this is always the case, you want to have a flexible interactive process to figure out what accommodation options so that there's no undue hardship. You may ask for supporting documentation should it be necessary to find out more about the person's limitations and disability and look at the position and the type of workforce. Obviously, if most people have received a vaccination in the workplace and this person would come in close contact, like I said a few minutes ago, there are other potential risks, then you have to weigh that. Obviously we can rely on CDC recommendations to look at accommodations that may be available and what may be reasonable. OSHA standards as well, things like ventilation and, cleaning and other things that go into, common areas, contact, close contact, et cetera. And of course, throughout this process, it's obviously against the law to disclose someone is receiving accommodation or to retaliate because they asked for accommodation. You can always say no to accommodation if it's not considered reasonable, but you can't retaliate because somebody asked you to, let them stay home and work the rest of their career because they're afraid to come to the office. I mean, that's not, you have to be, kind of professional, but say no if that's the outcome. So then we turn to another area that the EEOC's addressed. Well, is there, somebody can raise a religious objection to receiving vaccines. This has been something that's been around for a long time, such as there are people who, for religious reasons, don't get certain vaccinations for their children, and they have to go to a public school. And public schools, have those health forms that every kid who enrolls has to have been vaccinated for certain type of diseases. And this is always a potential that they run in conflict with. It's again same sort of analysis, because if someone has a bona fide religious belief, practice, or observance that prevents them from having the vaccination, again, it's a reasonable accommodation analysis unless it poses an undue hardship. Now, this, of course, is under Title VII as opposed to ADA, because religion is protected under Title VII versus disability under ADA. But, the undue hardship we're talking about in this context is what we consider more than a de minimis cost or burden on the employer. Also do consideration for the fact that not every religion or religious practice is going to be common or familiar. So if they're not from a more popular or generally known religion that you might come in contact with, does not mean that it's not a bona fide request. And so EEO says you should assume that the person's request for accommodation is a sincerely held belief and start from there. Now, of course, if you have some objective basis to question the validity of it, then you might be justified in asking for more supporting information. I mean, there have been a lot of things over the years that people have called a religion that has been debunked as just myth. But, I wouldn't be quick to call somebody who thinks they practice in a religion, it not being valid. So this is, again, kind of a interactive back and forth. So what do you do if you can't exempt or provide a reasonable accommodation after you've gone through all this? So again, you could exclude somebody from the workplace, but not terminate them per se. You might have to look at other rights under other laws, for instance, or come up with other options. Honestly, with telework rising tremendously, probably that's the first place you look if it's feasible, as far as I'm concerned. But, sometimes medical documentation, job descriptions, et cetera, are going to dictate whether that's, reasonable to the employer. Another area of concern with vaccines is GINA. There are 5 bullet points here that talk about what genetic information means under GINA. Just like we talked about earlier, there's going to be a pre-vaccine questionnaire. So if somebody is receiving a mandatory vaccine at the workplace, if you don't ask questions about genetic information, then there's no GINA implication. If you do ask questions about genetic information, then you have to be sure that you don't cross that line. And instead, again, this might be something you do in writing, that if the person's going to be vaccinated, they might want to just request proof instead of you as an employer giving the vaccination through your provider, et cetera, or on site. That may be a safer way of doing things. And of course, the act of just giving a vaccination, just as we said earlier, like with ADA, it doesn't get into a disability, it doesn't get into GINA because it doesn't involve the use of genetic information, because that's prohibited under Title II, as you can see here. Now, there's another issue that has come up, and it's technical, and I don't have enough time to go into it, but some of the vaccines use what's called mRNA technology, which deals with genetic makeup. And so there's a question as to whether those vaccines modify a person's genetic makeup. And therefore, if you require an employee to get a vaccine as a condition of employment, is this an unlawful use of genetic information? Well, thankfully, the CDC has said this doesn't interact with DNA in any way if it has mRNA in it, and it doesn't enter the nucleus of the cell, which is where we in our genetic makeup is. And so therefore, it doesn't matter whether the vaccine has mRNA or not, it doesn't violate GINA. So that's at least a pretty definitive way of looking at GINA, and it seems pretty safe for an employer, subject to what I said in the previous slide about the pre-vaccination questions. Now, again, as you probably have gathered or already know, so if it's not an employer-driven vaccination process, if it's coming from the employee's own healthcare provider, of course, one's own healthcare provider can ask questions about genetic information, the doctor shouldn't tell anything to the employer regardless. And we go back to having some kind of good documentation that tells the employee not to provide genetic information if they're going to provide proof they got vaccinated. That should protect you and your clients essentially from that issue. Then we have OSHA. So what about vaccinations in OSHA? Okay, if OSHA has said that with regard to other previous vaccinations, they haven't really chimed in yet under this vaccination, so we're still early in the process. But basically, if someone refuses the vaccination because of a reasonable belief that they have some kind of medical condition, it'll create a life or death situation, or they'll have a severe reaction to the vaccine, they may be protected under OSHA, which includes whistleblower rights. If they complain that they can't get the vaccine and they're treated adversely, they may be treated as a whistleblower and protected under the law. So if somebody objects because of a medical condition or a disability, you're going to want to look at that more closely. And again, look at what accommodations may be available. So would the vaccine implicate workers' comp? Well, it could, because first, someone has a risk of contracting or transmitting disease if they don't get vaccinated. And you have to weigh that with requiring the vaccination, which could have, adverse consequences like a reaction, or the person could get harmed, because as most of you have probably read, it's usually 3+ years for trials on new drugs, and we rush this through, and there could be unknown consequences down the road and health conditions that we didn't recognize. And this could end up, having some adverse effects on people in a significant way. So the belief is that many states would consider injury as a result of an employer-provided vaccination as being covered under workers' comp, which of course would then apply the exclusive remedy under workers' comp and limit your liability as an employer from any kind of tort claim. Of course, that remains to be seen. We have no test case. And so another question, very straight up, what's my risk here? What if I go ahead and do all this? I decide to mandate. Just like with the temperature checks and the COVID testing programs, we can expect plaintiffs' attorneys to make legal challenges for vaccination requirements. Other risks you have are obviously claims by customers, other employees who are going to assert they contracted the virus from an unvaccinated employee. And also that if your industry, if all folks have already, gone down this path and you resist and don't vaccinate your employees, some folks believe that increases a risk of the outlier or holdout employer in an industry that's already gone pretty much to the mandatory. And of course, all this is going to change over time, depending on developments, including industry, CDC, whatnot. The other thing I wanted to point out here is that there are state laws that have immunity statutes that may make COVID-related injury subject to the immunity where the employer is not liable, but that would require, compliance with all the requirements of best practices to avoid the immunity. So that's going to depend on the state, but I wanted to throw that out that could be covered under this. And so here are the best practices. If you mandate, pick up the cost of the vaccines, because unless it's covered by insurance, so that nobody has a financial barrier to work for you. Give employees options to opt out if they have medical or religious objections. And then obviously, if they have an objection, go through the interactive process. Don't leave it to frontline managers at clients to figure this stuff out. They're not trained and sophisticated in these areas. Legal counsel, HR are more prone to be knowledgeable and have handled these type of issues already. Another important area that I'm going to recommend is updating job descriptions. Put in essential functions, because it's kind of hard to do a combination analysis if you don't know what the essential job functions are. And there's some examples of things you might want to put in there that might have impact on COVID exposure, like travel, interaction with customers, et cetera. Obviously, medical records are to be kept separate from the regular personnel file, and you need to protect the data integrity and limit to who has access. And obviously, there's a general duty to provide a safe working environment regardless. So all that needs to be weighed in. And so I'm going to go ahead and stop and unshare, or stop sharing, not unshare, sorry. And then if anybody has questions right now, I'll entertain them for a few minutes. I mean, I know I want to keep this to 30 minutes, and I'm sort of there, but if anybody has something they want to ask, go ahead and use the chat function so then I can read out the question to everybody. Well, I do not see any questions. I'll give people one more minute in case they're not speed typers to see if they would like to ask. If not, I want to thank you again for attending. And again, this is sort of my give back to all you all for supporting me and for being great clients. As it's indicated on here, if you want to join my e-news list, let me know. I'm going to continue to do that. I'm going to try and make these regular webinars. I will post things on Twitter periodically. And of course, any feedback you have on these webinars is appreciated. It looks like I have a question. Okay. Nope. Somebody's got to go. Okay. Well, I want to thank everybody then. If you celebrate Christmas, I want to wish you a Merry Christmas. I wish you for a Happy New Year. I am going to do something on new laws in 2021, or I will do an update on stimulus or both. I don't know if I can squeeze it in between now and the end of the year, because I think most people are just ready to sort of get some downtime. But I'm going to try to keep you all in the loop one way or the other. I may just send out an email on some of this. But again, I appreciate all your support. I hope you got something out of this. And if you have additional questions or I can help you in these areas, you know how to find me. So be well, everyone, and thanks for attending.